Okay. Good morning. Today, we will be learning about introduction to legal philosophy in general and the significance of legal philosophy in the study and promulgation of laws that shape our history and the present society. So, at the end of this video, you should be able to reconcile and differentiate the foundational qualities of lawyers and philosophers, know their methods and the expected outcome of their thought processes. So you should also be able to appreciate the legal philosophy as an indispensable subject in the study of law and the usual questions that students of legal philosophy encounter along the way. So, class, when I was in grade 6, I was asked by one of my teachers of what I wanted to be when I grow up. So I told him I wanted to become a lawyer. Well, he said that he is doubtful if I could make a good lawyer because sabi niya, I was too honest and didn't know how to lie. So, yun ang akala niya. While yes, it is true, lawyers often face negative stereotypes, with some perceiving them as crafty manipulators or skilled deceivers. The reputation stems from the fact that lawyers must sometimes defend clients with questionable morals or use intricate legal strategies to navigate complex laws. Yet, despite the shady stereotypes, lawyers still command serious respect in society. Why? Because they're the ones who hold the justice system together, whether it's defending innocent clients, protecting human rights, or navigating legal labyrinths for the greater good. Lawyers play a crucial role in making sure society doesn't descend into chaos. So at the end of the day, love them or loathe them, lawyers are the necessary guardians of law and order. So, we usually hear people say, naku, yung mga lawyers, pampagulo lang yan, etc. Or sinasabi nila, kaya hindi matapos-tapos yung problema na to kasi yung mga abogado kasi lalong nagpapagulo. But lagi natin or minsan naririnig natin yan. But remember, there is an old saying that goes, everyone hates lawyers until they need one. So, kapag sila na yung nagkaka-problema, maghahanap din naman sila ng lawyers, right? So, with that remark of my former teacher, etong nanay ko naman, who really believes in me, she disagreed with that teacher. My mother was certain that I could make a good lawyer because according to her, I was always very philosophical in my arguments, often delving into deeper reasoning and abstract ideas to support my points. In short, philosopha. But she also reminded me to keep my thoughts subtle or I might end up spiraling into a philosophical rabbit hole and losing my grip on reality. So in simpler terms, baka mabaliw ako. So, thus my question is, do the paths of lawyers or do the paths of lawyers and philosophers intertwine or stand in contradiction? Lawyers and philosophers, while operating in distinct domains, share several foundational qualities yet differ significantly in their objectives, methods, and outcomes. Their relationship lies at the intersection of law, ethics, and logic, which are all critical to both profession. So, for law students, understanding this connection can offer valuable insights into how philosophical principles shape legal systems, as well as how legal reasoning reflects broader philosophical ideas. Philosophy serves as the foundation for much um, of what lawyers practice these days. So, the concept of justice, or a fundamental goal of the legal system, is rooted in centuries of philosophical thought. So, philosophers such as Aristotle, Kant, and John Stuart Mill have long debated what constitutes justice, fairness, and rights, and their theories underpin the laws and legal institutions we use today. So, for instance, constitutional law, often regarded as the highest form of legal authority, frequently draws on philosophical principles concerning human rights, liberty, and equality. When a lawyer argues a case involving freedom of speech or due process, they are not just engaging with statutes. They are also engaging with deep philosophical questions about what it meant to live in a free society. So, additionally, ethics is a point where the two fields heavily overlap. Lawyers must often grapple with ethical dilemmas such as how to represent clients they know are guilty, or how to balance confidentiality with the pursuit of justice. Philosophers, particularly those specializing in moral philosophy, explore these ethical questions in depth. So, a lawyer drawing on ethical reasoning is, in a sense, acting as a philosopher, balancing moral considerations with legal obligations. Both lawyers and philosophers engage with ethical reasoning, though from different perspectives. Lawyers often face ethical challenges in practice, such as conflicts of interest or decisions that impact people's lives. Philosophers, particularly those in ethics, explore these issues from a mere theoretical standpoint, asking questions about what is morally right or morally wrong. So, in both cases, ethical decision making is crucial, whether in the real world or in abstract philosophical debates. Um, One of the most significant differences between lawyers and philosophers is the nature of their work. Lawyers are practical problem solvers. Their arguments are intended to achieve specific outcomes in legal cases, whether that means winning a trial or settling a dispute or drafting a contract. So they work within a defined system of laws and procedures where the goal is often to resolve conflicts efficiently. So philosophers, on the other hand, they are more concerned with the theoretical exploration. They seek to understand and question the fundamental nature of reality, of morality, of human experience. So while lawyers deal with concrete cases, philosophers engage with abstract ideas. For example, a philosopher might ask, what is justice? So while a lawyer might be more focused on how justice is applied in a particular case. Um, Lawyers are bound by legal codes, statutes, and precedents. So they must work within the confines of law and are restricted in what they can argue. Legal systems impose um, rules that lawyers must follow, and their arguments must be based on established laws. So philosophers, in contrast, are not constrained. I mean, they are not constrained by any legal framework. They are free to question everything, even the very existence of laws. So philosophers can challenge assumptions that lawyers must accept, such as whether laws are inherently just or if certain rights are truly universal. Their freedom to explore controversial or unorthodox ideas sets them apart from the legal world, where rules and structures are paramount. Plus, you cannot expect a lawyer to argue with the judge whether or not this law is right or wrong, because the mere fact that it has been enacted, the lawyers has no authority to really question the authority of the legislature or the legislative body unless in a proper action filed in the proper court of justice, wherein there, of course, there's a remedy wherein counsels or parties may question the constitutionality of the law. So that's the only time. But when the law has been declared constitutional, even if when applied, it is harsh, no, on the part of the lawyer's clients. The lawyer is not expected to go to court and say, hey, you have to give consideration because law is too harsh, etc. No, unlike the philosopher's class, what I was saying earlier is that the philosophers, they're not bound with these rules. Okay? They can question even the law itself. So that sets them apart, the lawyers and the philosophers. Now, lawyers are outcome driven. They are focused. Well, ideally, lawyers are outcome driven, no? Hindi sila hindi tayo yung tipong pinapahaba yung kaso. Ideally, they are focused on achieving the best result for their clients or resolving legal conflicts. Their success is measured by winning cases, negotiating favorable settlements, or drafting effective legislation. Lawyers' work has immediate, real-world consequences. So philosophers, however, are more focused on the process of inquiry. They may not seek concrete outcomes or solutions, but rather strive to deepen understanding or broaden perspectives. In philosophy, the journey is often more important than the destination. Philosophers may leave questions open-ended or accept that some issues may never have definitive answers, while lawyers aim for resolution and closure. Because we have clients to defend or, whose rights we need to uphold. So, in conclusion, the relationship between law and philosophy is more than academic. Legal reasoning is grounded in centuries of philosophical debate, and the ethical dilemmas lawyers face often require philosophical reflection. Both fields demand rigorous thinking, ethical consideration, and strong argumentation skills. However, while lawyers operate within the confines of the law to achieve practical outcomes, philosophers enjoy the freedom to explore abstract concepts and question foundational assumptions. Okay, so now let's proceed with the significance of legal philosophy in the study of law. Well, you must have encountered already the origin of the word philosophy. So philosophy is taken from the Greek words philos and logos, which means love of wisdom. So philosophy is the study of the universe that seeks to know the truth and the rational explanation of anything. But how about legal philosophy? So legal philosophy, often referred to as jurisprudence, is a branch of philosophy that examines the fundamental questions and concepts underlying the field of law. It seeks to understand the nature, the purpose, and the principles of law, as well as its relationship with morality, society, and governance. So, at its core, legal philosophy grapples with abstract and theoretical questions about the nature of law and its role in human society. In legal philosophy class, you will also deal with the nature of law, its purpose, the sources of legal authority, the interpretation and application of laws, law and morality, justice and rights, legal systems and institutions, and of course, contemporary debates. Nature of law. As to the nature of law, one of the central inquiries in legal philosophy is defining what law is. So what is law? So scholars and philosophers have debated whether law is a set of rules, commands, principles, or something else entirely. Understanding the nature of law helps us recognize its distinguishing features and how it differs from other normative systems. So there's also this concept or the question on what the purpose of law really is. So legal philosophy asks why societies have laws and what purposes they serve. This involves exploring questions about the role of law in maintaining order, promoting justice, protecting individual rights, and contributing to the common good. Different legal theories propose various purposes for the law, which can range from social control to moral guidance. Also, students of legal philosophy also deal with different sources of legal authority. So legal philosophers, they examine where the authority of law originates. Some argue that law derives its authority from human sources such as legislation or judicial decisions. That is the concept of legal positivism. While other legal philosophers, they assert that law should be based on higher moral principles of natural law. Okay? So this debate has profound implications for legal systems and their legitimacy. Legal philosophy also delves into the methods and principles used to interpret and apply the law. Questions about how judges should approach statutes, precedents, and constitutional provisions are central. This aspect of legal philosophy shapes decision making and the development of legal doctrine. So, again, what are the things that legal philosophers or students of legal philosophy encounter in the study of legal philosophy? First is the nature of law. Next is the purpose of law. Another is the sources of legal authority. The fourth one is the interpretation and application. Um, As to law and morality, the relationship between law and morality is perennial topic in legal philosophy. So some legal theories like legal positivism argue that law and morality are separate and distinct, while others like natural law theory contend that there is an inherent connection between the two. This debate has implications for the ethical foundation of legal system. So legal philosophy explores the concept of justice and the nature of rights. Questions regarding distribution of sources, the protection of individual liberties, and the rectification of injustices are common themes. So ethical theories such as deontology, consequentialism, and virtue ethics are often applied to analyze these issues. Legal systems and institutions. So this is also one of the key concepts, or the key areas in the study of legal philosophy. Legal philosophers also consider the structure and functioning of legal systems and institutions. So this includes questions about the legitimacy of legal authorities, the role of judges and lawyers, and the relationship between domestic and international legal systems. So I mentioned earlier that there are contemporary debates regarding legal philosophy. So legal philosophy is not static. It involves alongside societal changes and new legal challenges. Contemporary debates include topics like human rights, environmental law, artificial intelligence, and ethics, and the globalization of law. So in summary, class, legal philosophy is an intellectual pursuit that seeks to explore the foundational principles and concepts that underpin the legal system. So it provides a theoretical framework for understanding law's nature, purpose, and role in society, making it a critical field of study for legal scholars, practitioners, and anyone interested in the principles that govern human behavior in a legal context. So the study of legal philosophy or studying legal philosophy is very important for law students for several key reasons. Okay, so mhm. Okay, so um, first is foundational understanding. Okay, let me go back. Okay. So, significance of legal philosophy in the study of law. First is, of course, foundational understanding. So, legal philosophy provides the foundational concepts and theories that underpin the study of law. Understanding these concepts help students grasp how legal system function and why laws exist. Another important reason why law students should study legal philosophy is that it develops critical thinking skills. So, engaging with philosophical questions encourages law students to think critically. They learn to analyze arguments, question assumptions, and explore the implications of different legal theories, which is essential for effective legal practice. It also aids in understanding and interpreting the law. So, legal philosophy equips students with tools to interpret and apply laws more effectively. So it helps them understand different approaches to legal interpretation, such as textualism, intentionalism, or purposivism, which are important in legal practice. It also encourages ethical considerations. Law often intersects with moral and ethical questions. So, studying legal philosophy encourages students to consider the ethical implications of laws and legal decisions, helping them navigate complex moral dilemmas in their future careers. So, it is also important in the understanding of justice and fairness. Legal philosophy explores concepts of justice, fairness, and equality. Law students learn to critically evaluate whether laws serve the common good and protect individual rights, which is essential for advocating for just outcomes. Another important reason why you should study legal philosophy is for legal reform. Okay, by understanding legal philosophy, students can engage in discussions about legal reform. They can identify the injustices within the legal system and advocate for changes that align with ethical principles and societal needs. Another is to enhance communication skills. Philosophical discourse requires clear and precise communication. Engaging with complex ideas help law students improve their ability to articulate arguments, debate issues, and communicate effectively with clients, colleagues, and judges. It will also prepare the student for diverse future legal careers. So legal philosophy prepares students for various legal careers, including litigation, public policy, academe, and advocacy. So a strong philosophical background helps them navigate helps them navigate different roles and contexts within the legal field. So, and then of course, it exposes students to interdisciplinary perspective. Studying legal philosophy exposes students to interdisciplinary connections, enriching their understanding of how law interacts with politics, sociology, and economics. So this broader perspective can enhance their legal analysis and problem solving skills. in summary, studying legal philosophy is essential for law students as it provides foundational understanding of law, develops critical thinking and communication skills, fosters ethical awareness, prepares them for diverse careers, and enhances their ability to advocate for justice and reform. Engaging with legal philosophy ultimately shapes more thoughtful, informed, and effective legal professionals. So, as a student of legal philosophy, you will soon encounter key questions, no, in legal philosophy. So, certainly, legal philosophy grapples with multitude of key questions, so each of which plays a pivotal role in shaping our understanding of the law and its place in society. So, for example, one key question is, what is law? What is law? So this is perhaps the most basic question in legal philosophy. So what distinguishes law from other forms of social control or regulation? Is it merely a set of rules and commands, or does it encompass broader principles and norms? So another question is, what is the purpose of law? Why do societies create, and why do societies create and enforce laws? So is the primary purpose of law to maintain order, promote justice, protect individual rights, or achieve some other objective? So different legal theories propose various answers to this question. Another key question is, where does the law, or where does legal authority originate? So what gives law its authority? Does it come from human sources like legislatures? Bakit natin susundin yung batas? Sinong nagsasabi na dapat sundin yung batas? So does it come from human sources like legislatures and government? So this is, as what I told you earlier, the concept of legal positivism. Or is there a higher moral source of authority as discussed in the natural law theory? So this question has significant implications for the legitimacy of legal systems. Okay. How should laws be interpreted and applied? That's another question. Legal philosophy examines the methods and principles used to interpret and apply laws. Should judges rely solely on the texts or on the statutes? Consider legislative intent or apply broader principles of justice and fairness? So when should the judge apply the principle of justice and fairness? Is it automatic? So this question is crucial for judicial decision making. Another key question is, what is the relationship between law and morality? Do legal systems have a moral foundation, or are they separate from the moral considerations? Legal positivists argue for the separation of law and morality, while natural law theory suggests a close connection between the two. What is justice? Another question. How will we say, or how will we know that there is justice, or that justice has been served? And how do we achieve it? So justice is a central concern in legal philosophy. What constitutes a just society, and how do we ensure just outcomes within legal systems? Different ethical theories such as utilitarianism and deontology offer varying perspectives on justice. And then there's a question of, what are rights, and should they be protected? So Legal philosophers explore the nature of rights and whether they are inherent to individuals or conferred by the state. Questions also arise about the limits of rights, especially when they conflict with the greater good or other rights. What role does the state play in regulating behavior? So, another key question. Legal philosophers explore the nature of rights and whether they are inherent to individuals or conferred by the state. So questions also arise from the limits of rights, especially when they conflict with the greater good or others. What role does the state play in regulating behavior? Legal philosophy examines the scope or state authority in regulating individual behavior. How much power should the government have in matters of personal liberty, property, and privacy? So another is, what are the ethical limits of law? No? So those are the questions that you may encounter or that you will encounter while you study legal philosophy. How do legal systems evolve and adapt? As you know, as society changes, legal systems must adapt. Legal philosophy explores how legal doctrines develop, how precedents are established, and how law responds to technological advancements and shifting cultural norms. There is also this question about international law and sovereignty. So legal philosophy also extends to the realm of international law. How should international legal norms be established and enforced? How does international law interact with the sovereignty of individual states? Is there such a thing as international constitutional law or international code, which all sovereign states must adhere to? So do we have that at present? So these questions are not only theoretical, but also have practical implications for the development, interpretation, and application of legal systems. So legal philosophers, jurists, and policymakers grapple with these questions as they shape the laws that govern societies and impact the lives of individuals. Exploring these questions deepens our understanding of the law and its role in promoting justice, order, and fairness in the world. So, as your activity, um, please answer the question. As a student, what aspects of legal philosophy do you think would capture your interest and motivate you to study it? Kindly provide your answers in the comment section in not more than 3 sentences. Good day.